Hi everyone, we're here to talk about tourist visa overstay, what will happen next, and the impact of Immigration and Nationality Act Section 222, letter G. A tourist visa holder who overstays the authorized period, or if the USCIS or immigration judge formally finds out that there was a violation of status, for example, you work without authorization, the visa that you used when you entered the US is void. Let's hear a story. Ben was granted a B2 tourist visa valid from January 2020 until January 2030. It's a 10 years validity. On November 2, 2020, Ben arrived in Miami, Florida. His I-94 says he can validly stay in the US until May 2, 2021. It is now May 20, 2021, and Ben did not return to his home country. He did not even file an extension of stay. So Ben overstayed. What will happen to Ben's tourist visa? Ben's tourist visa will be voided. Even though the visa will expire in 2030, he cannot use it anymore. Ben cannot be readmitted to the US until he reapply for a new visa in the consular office located in his home country. In our example, Ben only overstayed for 18 days. What if Ben overstayed much longer? If Ben overstayed for more than 180 consecutive days, but less than 1 year, then decided to leave Florida and return to his home country while there is no deportation yet, he will be prohibited to return to the US for a period of 3 years. If Ben overstayed for 1 year or more and decided to leave Florida, he will be prohibited to return to the US for a period of 10 years. This was just a brief explanation about the effects of unlawful presence. Unlawful presence is when a person is present in the US after the expiration of an authorized stay. For more information, please visit the USCIS website. I'm inviting everyone to please join us on our FB group page, Green Card USA Immigration Discussion. More immigration topics coming up in the following episodes. Thanks for watching.